Hello, everyone. I sort of feel thrust into the middle of this, not knowing whether I'm actually live or not. But very warm welcome to our session this afternoon on rebooting the WTO. My name is Christian Bluth. I'm a project manager with Bertlesmann Stiftung, and I'm responsible for our activities on WTO reform. But these activities are not really in the foreground of today's session. We have a session on Friday morning on how to deal with the negative spillovers of industrial subsidies and state aid, and I invite you to attend this. But today we are going to talk about rebooting the WTO as a package. It's a commonplace now that the WTO is in crisis, and that means it's actually a multiple crisis. It's a crisis of its judicial arm, it's a crisis of its negotiation arm, and it's a crisis of its transparency, governance, deliberations arm. So however you're going to fix this multiple crisis will require not one single act of WTO reform, it will require a package. And there are many good ideas out there what this package could in fact look like. What we want to do in this session is to go through the ideas that are there, try to make sense of it, try to think about how would you go about WTO reform, how would you do it in a way that you find political support for doing this, that you generate momentum for further reform and for modernizing the organization. I'm delighted that I have an absolute stellar panel around me to make sense of these questions. And I'm absolutely delighted to welcome, and I'm going to go in the order of speaking, Simon Lester, Simon Evanet, Inu Manak, and last but not least, Jonathan Freed. So what we thought we would do in order to make sense of the big question of rebooting the WTO is that we go first through the different areas of crises. This is what our first three speakers are going to do. So Simon Lester, who is Associate Director of the Herbert A. Stiefel Center for Trade Policy at the Cato Institute, is first going to take us through the troubles of the judicial arm and what can be done about them. After which we are going to hear from Professor Simon Evanet from the University of St. Gallen and the mastermind behind the Global Trade Alert, what can be done to improve governance and transparency. Inu Manak from the Cato Institute will then update us on negotiations and where there is actually room for maneuver there. And then finally, I'm absolutely delighted that we have Jonathan Freed with us, who is a former Canadian ambassador to the WTO and or a permanent representative to the WTO and G20 Sherpa. And he's sort of trying to make sense of all the different ingredients and try to help us find a package and try to make sense of it all. I'm absolutely looking forward to this and to the discussion that is following, and would like to yield the floor to Simon Lester. Simon, go ahead.
Thank you very much, Christian. Good to be here with my fellow panelists and with everybody watching around the world. Thanks to the Geneva Trade Platform for putting this on. So as Christian said, we're here in this session to talk about rebooting the WTO in three separate areas. We have the judiciary, we have governance, we have negotiations, and I suppose it's debatable which area of the WTO is most in need of a reboot. It's not really a contest. We're not here to convince you that our area is the most important, but certainly there's a case to be made for dispute settlement, where currently we have a right to appeal, but no functioning appeals court. You can't get much worse than that. Although I shouldn't tempt fate here, things probably could actually get worse. So in thinking about what a reboot would look like, let me start things off by stating something fairly obvious. If legal obligations cannot be enforced, their value is greatly reduced. And international law is famous for its emphasis on soft law, law that can't be enforced very well. But trade rules in general, and the WTO in particular, stand out in international law as being relatively enforceable. WTO dispute settlement has been one of the most developed and legalistic adjudication systems that exist in international law. Now, the precise scope of the WTO dispute system's authority is a proper subject of debate. Just how enforceable should the rules of the WTO be? There are degrees of enforceability, and it's up to the governments who make up the system to decide how much judicial or quasi-judicial, if you prefer, power they want to see. The prior trade dispute system that existed under the GATT was less enforceable than what we have in the WTO. So at the GATT, losing governments could block the adoption of GATT panel reports, and that meant these reports had no legal effect. As part of the creation of the WTO, governments changed the rules in this area towards greater enforceability. Adoption now was, for all practical purposes, automatic. So WTO dispute settlement reports always have legal effect. At this time, governments also added an appeals mechanism called the Appellate Body to review panel reports to ensure that these now automatically adopted reports were of sufficiently high quality. And in its early years, the Appellate Body received a lot of praise, more praise than criticism. But recently, the United States in particular has offered strong objections to some of the rulings and the behavior of the Appellate Body. And the Trump administration has used these objections as justification for blocking appointments to the Appellate Body, which is now down to one member. It's no longer operating. So there's now a fear that the WTO dispute settlement system, without a functioning Appellate Body, has been brought back to the GATT or even pre-GATT in terms of the degree of its enforceability. Other WTO members have not been willing to give up on appellate review. They've pushed for a negotiated solution here with suggested changes to the process that might satisfy the United States, but a resolution does not seem to be imminent. They have also put forward a temporary replacement appeals mechanism known as the Multi-Party Interim Appeal Arbitration Arrangement. It's quite a mouthful. We'll just call it the MPIA, to keep the system functioning until a permanent solution can be found. So as of July 31st, we have the MPIA in effect for the 24 parties who have signed on, and other WTO members may join at any time. So this brief background takes us up to our discussion of a reboot. If we are doing a reboot, we can, in theory, have anything we want here. There are plenty of options. So recently, U.S. Trade Representative Robert Lighthizer wrote an op-ed where he suggested something more like commercial arbitration, without all that pesky reasoning that leads to jurisprudence. Alternatively, we could just have a one-stage panel process without all that pesky appellate reviewing. Less drastically, we could change the scope and nature of appellate review from where it has been under the Appellate Body. So what I'm going to do now is talk briefly about some questions related to the MPIA, which is the reboot currently on the table, or at least a patch to keep the system running until we get a proper reboot. And then I'm going to focus on a bigger systemic question. Why do we need that second tier of dispute settlement anyway, this appellate review? Is it really worth all that hassle? Would our lives be easier if we just deleted it from the DSU as part of a reboot? So I'll give you the spoiler. In my view, yes, it is worth it, and no, we shouldn't get rid of it. But quickly on the MPIA. The European Union has led this effort to use the general arbitration mechanism in DSU Article 25, which is a very broad provision that basically just says you can arbitrate disputes if you want to, as the basis for appeals. And this initiative is joined by 23 other members. So the MPIA appeals are only available to parties to the MPIA, but other WTO members may join at any time, and the procedures could be used on an ad hoc basis. So in theory, this can apply broadly as a temporary replacement for the Appellate Body. I think the EU is doing the right thing here by trying to ensure an opportunity for appellate review. However, just as there was uncertainty about the Appellate Body in 1995, there is uncertainty about the MPIA now. So here are a few questions to think about when considering the MPIA as a reboot option. First is, how often will the MPIA appeal process be used? Many frequent users of the dispute settlement system are not members and have seemed reluctant to join. There aren't many disputes in the pipeline between the MPIA parties. Another question is, what kind of legal culture will develop around it, including the approach of the arbitrators and of the litigants themselves? And how much deference will the MPIA show towards politically sensitive domestic laws and regulations? And how much deference will it show towards the finding and reasoning of panels? Now, only practical experience will give us clear answers to this question. We didn't really know what we were getting with the Appellate Body, and we don't know what we are getting with the MPIA. So, if we don't know what we are getting, why bother with all this? Why do all this work? What exactly is the value of appellate review? The initial thinking behind creation of the Appellate Body was somewhat narrow. Correct egregious mistakes in this newly automatic adoption system. But now that we've had it for 25 years, we have a better sense of it. we can think more deeply about the role of appellate review. Why might you want a two-tier system in the WTO? What are the flaws with having a one-tier system? I see two main benefits to this second tier. The first is, as the DSU drafters thought, the quality of panel reports can be an issue. Sometimes people make mistakes, and it's good to have someone there to take a second look. Now, just to be clear, I'm not questioning the quality of panels' work relative to that of the appellate body. I wouldn't say the panelists in the legal affairs or rules division do lower quality work than the appellate body and its secretariat. Rather, I would say there are two things going on. First, the second look at an issue simply has an advantage over the first look in terms of quality. The second look has the first look's analysis to guide it. And second, panels are often overwhelmed with 10 or 20 or 30 or 40 claims and a complicated set of facts. They can only devote so much time and effort to all the legal issues they face. If they botch the legal interpretation of claim 28, it may be because claims 1 to 27 wore them down. So it's just good to have someone there to take a second look. The second reason for appellate review, putting aside mistakes, sometimes people just disagree about issues, which is fine, except that this is law, and we want to know what the law is. So we have these core principles, such as non-discrimination, that govern the system. If different panels offer different interpretations, and there are some pretty big differences in view out there on what non-discrimination means, the system loses effectiveness, and the law becomes incoherent. Can we get coherent jurisprudence with a single-tier system? Maybe. If you had a permanent panel body and a mechanism for panelists to discuss cases with each other, we might be able to avoid inconsistent rulings. And if a member wants to propose that, certainly worth listening to. But in the current context, I'm not sure either side, the US on one hand, or just about everybody else on the other hand, could accept this. So just to be clear, we can survive with that second tier. Life will go on, but in my view, for the reasons I noted, I think we're better off with it. Are there possible downsides to the second tier? Yes, it does take extra time, 90 days maximum under the DSU, or more than a year recently. A faster process is a better one, and appellate review does slow things down. The creation of an independent institution does have the ability to then expand its own power, which some are okay with, but others are not. Obviously, the US saw this as a downside. So would an ad hoc appellate mechanism work better? Just the second set of eyes without a permanent body with a mission of coherence? I prefer the permanent body, but I can see some advantages with something more ad hoc. I think you would have trouble achieving the coherency that I said is important, but it's something that should be on the table. So on balance, though, taking a holistic approach to all of this, as panels in the appellate body tend to do, I think we were better off with that second two-tier system and a permanent institution. So with all that in mind, where do we go now? What do we do? What is our practical way forward? Look, there have been no indications that the Trump administration's trade policy team will change its mind about appellate body appointments. So if on November 3rd, Donald Trump wins the presidential election, the United States is likely to continue its current course of blocking appellate body appointments, and the MPIA experiment will begin, and we'll see how it goes. On the other hand, if Joe Biden wins the election, I think it's possible that the United States will be more amenable to compromise in the appellate body, in the effort led by New Zealand Ambassador David Walker to forge a compromise. At least some of the U.S. concerns have been addressed to some extent, and perhaps with the Biden administration, a negotiation can begin again over how to reform the appellate body and get appointments moving. I think it's fine to debate every aspect of what appellate review should look like. What is the scope of reviewable issues? Should the facts, should the law all be in play? What is the standard of review? How much deference to give to panels or to domestic laws and regulations? What is the nature of this institution? It should all be on the table. But I do think the government should ultimately come down on the side of some form of a two-tier system with appellate review is the best way to ensure that the WTO dispute settlement system remains credible and effective. So I'll end there, and I look forward to coming back to this in the discussion, and I turn it back to Christian to keep things moving along.
Thank you very much, Simon. That was absolutely very interesting. I have forgotten one important thing in my introduction, which is that we want this session to be as interactive as possible. And therefore, I would like to invite you, the panelists, to put any questions that you might have in the Q&A box, and then I'll get to them in a way that makes sense. Right, so we've heard a couple of really good ideas about how we can fix the problem of the judicial arm of the WTO. But as you know, there is also a substantial problem in the governance of the institution to some degree, or some elements of it. And Simon Evanet is going to present some ideas how the performance there can be improved.
Thank you, Christian. And let me congratulate the Geneva Trade Week team for putting on this fabulous event and bringing us all together. I'm going to discuss the transparency function of the WTO, which is an important ingredient in the WTO's deliberative functions. I'm going to make a diagnosis, then I'm going to suggest that this raises 3 questions, and then put on the table a 3-part proposal. The diagnosis starts off by noting that transparency has been a long-standing problem at the WTO, especially in the area of non-tariff measures. We have seen this in the context of the reports on the G20 governments, where unfortunately information on economic support measures and subsidies has not been forthcoming from many members of that group. This problem has got worse during the COVID pandemic, and recently Bernard Hoekman has done a detailed apples for apples comparison between the notifications to the WTO and those reported in an independent exercise, and found that for every 1 notification to the WTO, in fact, the independent exercise had found on average 10 interventions. And so this is a concern that is, I think, getting worse over time. There are bright spots in notifications. People often point to TBT and SBS, and it must be conceded that there are thousands of those submissions. However, the utility of that information is seriously compromised by a lack of consistent categorization of the products involved. Indeed, there are 2 sets of product classification systems used in TBT and SBS, and not every notification has any one of those codes or a code from either system employed. So even at the cutting edge of WTO notification, we have deficiencies. The problems that we have here, and now I move more towards the diagnosing the causes here. The problems here are not with the Secretariat, they're with the members, the WTO members themselves. And essentially the root cause of this is, I think, an unwillingness of governments to be held accountable for their actions to other WTO members. And consequently, it belies their government's commitments to their WTO obligations, especially their binding trade obligations. So transparency may sound like a very a second order issue, but it goes to the very core of countries living up to their obligations that they've signed on to. Now, the reason we care about transparency is because we know that a lack of transparency and the uncertainty it creates is both a trade barrier, an investment barrier, and has become a source of trade tensions between countries as accusations are made backwards and forwards, especially in the area of subsidies. So we have a problem, and it goes right to the core of whether governments are actually willing to live by their binding trade obligations. Now, if we fix this problem, I need to also make a note of caution, which is that fixing the transparency problem doesn't render the system perfectly operational. It is only a necessary condition for a predictable system of trade regulation. Transparency must be accompanied by effective deliberation and dispute settlement. So that's my diagnosis. I think 3 questions follow from this. The first is how much of the gains from the Uruguay round have been reduced or lost because of growing non-transparency of the WTO? So how much are we losing? How much are we going backwards because of this lack of transparency? The second question is as follows. Realistically, can a public international organization be both a convener of governments and a monitor of those governments? And that question was really rammed home to me recently in reading an article in The Economist magazine about the World Health Organization, where one long-standing former health minister from the United Kingdom actually said it's impossible to expect the WHO to be an effective monitor of governments if it wants to be a convener. And that made me wonder, indeed, why do we lump these 2 responsibilities, convening and monitoring, into the same organization? After all, in the area of agricultural subsidies and the like, essentially, a lot of governments rely on the great work of the OECD. So why must we expect the WTO also to engage in monitoring as well as in convening? Or let me put it this way, if there's there's no reason why this configuration has to be this way. Now, my third question then is, if the WTO is to both convene and monitor, what steps should be taken in order to improve matters? And here I want to highlight that in session S37 of the Geneva Trade Week, we will be having a discussion about how the WTO can learn from monitoring and transparency in other policy domains. And I think I hope you can join that session, and I hope we can see if there are any possible lessons from the areas of bribery, procurement, and the like, which we can translate over into WTO trade regulation. So these are the three questions then. How much have we lost? Can the WTO realistically be a convener and a monitor? And thirdly, if it is going to do both functions, what should be done? What steps should be taken and by whom? Let me just close then with a three-part proposal, which I think could help take things forward. And it involves the following. First, we should empower the WTO Secretariat to independently collect information on government acts. This will require more resources to be devoted to this function. And it's not just human resources we need here, but good IT resources, because of course now we have the capability of tracking and monitoring what goes on government websites in real time. So now is the time, I think, for the WTO Secretariat to be allowed to use big data tools to be able to track what governments are doing. The second reform would be that there should be no veto by WTO members concerning the publication of information on members' acts. I would say that WTO members should be able to post comments on any measure that the Secretariat finds, but I think there should be nothing holding back the Secretariat. And of course, the Secretariat would use its own common sense and not publish ridiculous information. After all, their reputation is at stake as well. And the third thing I would recommend is that the WTO Secretariat create an open portal where information on state acts can be supplied by WTO members and by third parties. And the submissions to that portal should be made public, and the WTO Secretariat would be under an obligation to review those submissions, and then, of course, if they find anything which is of interest, publish it in their own listings and tallies of government acts. So I think this is an area, transparency is a critical area. It has been one where we have gone backwards over the last 10 to 20 years, but this is an area where we can turn the corner, and the three steps that I've laid out would be one way to take this forward. Thank you very much.
Thank you very much, Simon. Lots of interesting ideas there and food for thought. One thing that has been highlighted as being a particularly unhelpful element of the crisis of the WTO is that negotiations have been very slow to go forward, and that indeed the failure of the Doha round is one of the big problems that the organization as a whole has never overcome. Ino Manak from the Cato Institute is going to tell us what we can expect from the negotiations arm and how we can move things forward there. Ino, the floor is yours.
Thank you so much, Christian, and thank you for the organizers of Geneva Trade Week for bringing us together virtually for this week. It's great to be here today. Now, this session has been tasked with exploring options to reboot the WTO. Now, I think while all WTO members may disagree on these specific items that are in need of a reboot, as we all might do, we have come to a point where there is general consensus that things do need to change. My remarks are going to focus on one aspect of the organization that could benefit from renewed thinking, and that is negotiations. Now, negotiations are a critical pillar of the WTO, but the organization has not succeeded in negotiating any new multilateral deal since its founding. Now, this is not a failure of the institution, but rather a failure of its membership. The political will to conclude ambitious multilateral agreements died with the Doha round, which never came to fruition. But this doesn't mean that we need to do a hard reset. We don't need to turn the WTO off and on again, so to speak, but perhaps it's time we finally installed those much needed updates to our operating system. And in the midst of its current existential crisis, what the WTO needs most urgently is for its members to approach negotiations with an eye to the future, but informed by the past. This will require us to address what I think are two major challenges to rebooting negotiations. First is finding a new approach to the development dimension. And second is to build consensus on priority areas for new rules so that the WTO stays relevant and at the center of the world trading system. Now I'm going to address both of these in turn. So while Doha seems like a very distant memory to many, calls to simply move past it will do nothing to reset the negotiating pillar of the organization. Let us remember, this is supposed to be the development round. But where are we on issues of development? The preamble to the Marrakesh Agreement states we shall continue to make positive efforts designed to ensure that developing countries, and especially the least developed among them, secure a share in the growth of world trade commensurate with the needs of their economic development. Now, developing countries have benefited greatly from liberalized trade. In fact, exports to developing countries account for almost half of total world exports, and the largest 15 developing countries account for 3/4 of that export share. But can we say that we've lived up to the spirit of Marrakesh? I don't think we can. But the reason we can't is sort of a combination of failures on the part of both developed and developing country members. Developed countries fight hard in negotiations to see how little they can give in terms of concessions and still have protected sectors where developing countries have a competitive advantage. And developing countries have fought equally hard to preserve a dichotomy that does not well reflect differentiation among them. Thus, the poorest developing countries are made worse off as larger developing countries continue to ask for special and differential treatment. Now, in 2019, the United States proposed a change to the grant of special and differential treatment by calling for greater distinctions between what it termed advanced developing countries and those that we can consider developing by certain metrics. Now, the metrics the US put forward aside, which I don't think are likely to be the best way forward on this issue, but it does raise an important point here. The world has dramatically changed since the WTO was established, yet the approach we have taken to development has remained the same, despite the fact that some developing countries leave a much bigger imprint on world trade than others. And no other issue, in my opinion, exemplifies this problem better and provides actually an opportunity to solve it than the current fisheries talks. Now, while these discussions have a long history and it looked like they were progressing well from 2005 to 2011, the negotiations were not really a top priority for WTO members until after the UN General Assembly adopted the Sustainable Development Goals in 2015, which set a 2020 deadline to eliminate subsidies that contribute to illegal, unreported, and unregulated fishing, as well as some subsidies that lead to overcapacity and overfishing. Now, one of the major snags in these talks is how to address the development dimension. And it's tricky because 9 out of 15 of the largest marine capture fish producers are developing members. China has been the top exporter of fish and fish products since 2002, and India holds the fourth spot at 2017. Now, despite this, China has been one of the most ardent defenders of SDT, regardless of particular development needs. And in a 2019 communication, it called for reasonable policy space in fisheries rules and appropriate and effective special and differential treatment. Now, India has also been very reluctant to change the approach to S&D and has itself called for more of the same, phase outs and blanket exemptions in some cases. This despite the fact that it doesn't heavily subsidize its fisheries, but it might like to in the future. Now, this mindset has to change for negotiations to be successful. Importantly, the fisheries talks must be multilateral. The last time I checked, fish don't respect territorial boundaries. Overfishing is by definition a global problem requiring a global solution. Developing countries in this sense have in some ways the most to win, but also the most to lose, as they depend on fish for both livelihoods and for food. And if they don't take on ambitious commitments now as well, this could be a self-inflicted wound that will in the long term hurt the sustainability of our oceans. But let's also remember, who are the 5 main providers of fishery subsidies? It's China, the European Union, the United States, South Korea, and Japan. And these countries account for 58% of all global fishery subsidies. These members must recognize that they are the biggest part of the problem and avoid trying to create so much flexibility for themselves that it makes the agreement merely symbolic. Now, I raise the fisheries talks in particular because I think it also helps to set the stage for what I think is the second major challenge: building consensus on priorities for negotiations. The issue of fisheries is an interesting one because it best illustrates the modern challenges to trade and the overlap of various issues areas. So this is not just about subsidies, but also environmental sustainability and development as well. And how we navigate the intersection of these issues will be an important test of the WTO's ability to adapt to these new circumstances. But the trade landscape has changed so much since the WTO's establishment that it's difficult to agree to what we should even be talking about sometimes. The e-commerce talks are a great example here. Members disagree not only on the substance of the talks, but also on whether these issues should be given a priority at all, when so many WTO members lack the digital infrastructure to allow them to compete in this space in the first place. So many will simply be takers of the rules, and this rightly creates some frustrations among the membership. Now, if these e-commerce talks progress, members should be mindful of this and aim to craft rules that do not create additional obstacles for developing countries for taking advantage of digital opportunities, and a commitment to capacity building will therefore be essential. But if we take ourselves back to the Doha Development Agenda, the only issue that members were able to pull off and succeed in negotiating so far from that mandate was trade facilitation. And that agreement entered into force in February 2017. 151 members have now ratified the agreement. Now, the TFA, I think, provides some lessons in prioritization. It took an issue that clearly affects every member. It crafted rules that help members participate and plug into the world trading system, making it more inclusive. And members' obligations were structured in a way that recognized the challenges to implementation for developing countries. The TFA actually used a novel approach to addressing the development dimension by allowing parties to self-identify specific short and long-term implementation timelines, as well as those provisions for which they will require technical assistance. Now, this approach is novel in that it links differential treatment to an identified need, as opposed to a general opt-out on certain commitments. Now, this is a hopeful way forward for future talks, so I think there is still some room to improve upon this model. Now, there are many more issues we should be negotiating. Environmental goods, for instance, and services, which seem to have been nearly abandoned. And of course, we should also be thinking about updating and expanding past agreements. Given the current pandemic and seeing the protectionist responses to it, it may be worth considering expanding the WTO pharmaceuticals agreement to include all health products and services. There are 34 members on this agreement so far, and that actually includes the EU as a bloc. So we can certainly do better here. Now, I'm just going to conclude with one final thought here. Building consensus, particularly in the current environment that we're in, is going to be incredibly difficult. But if we can't agree on a set of priorities for the world trading system, I think we're going to be in a lot of trouble. The WTO risks fading into irrelevance if it is not the default table that all members decide to come and sit at for negotiations. Thank you, Christian. I'll turn it back to you.
Thank you very much. Very interesting thoughts. And I couldn't help thinking about one bit of research that we as a team do generally, which is a survey amongst people in some developed and emerging economies, so overall 12. And it turns out that actually satisfaction with globalization is much higher in emerging countries than developed. And that's maybe a hint of something that we might have to discuss as well. But let's keep that for the general Q&A. And let's now turn to Jonathan Freed, who will help us to make sense of all these different ideas and maybe help us to see a package of WTO reform and how this can be taken forward. Please go ahead. Floor is yours.
Christian, I would have said thank you, except you've given me a very tall order. I've learned a lot from my colleagues on this panel, not only in this session for many years prior, and I'm continuing my education today, and I certainly appreciate the efforts of the Geneva Trade Platform and its partners in organizing a virtual public forum through this trade week. So taking all the observations into account, if there's one fundamental common theme among our panelists, in my view. It is quite simply that we've seen the enemy and it is us. The responsibility and the burden of breaking what is a continuing logjam rests with the member governments themselves. It's not the Director General or the Secretariat, it is the membership in this always categorized member-driven organization that have fallen short of their responsibilities in each of the areas identified, in administering the current rules, in enforcing and overseeing respect for the rules, and in exercising what has been given to them under the WTO agreements, which is the legislative function of moving the rules forward. Let me elaborate a bit on each of those, taking the themes that we've identified in turn. Let's recall the basic bargain that led to the WTO dispute settlement regime. At the time of the Uruguay round, there was tremendous concern even then with unilateral action, unchecked by any agreed disciplines, and in particular at that time, the infamous US Section 301 powers. And the deal that was reached, in effect, said, well, United States, we recognize you're going to reserve the right to act unilaterally. We've read your legislation. It takes about a year for the petition to be made and the review to be made. But why don't we devise a regime that leads to some check on that power that will be completed within your timetable, and thus exercise some constraint on what would otherwise be unilateral action. That's one of the reasons for the strict timetables originally codified, was to marry the WTO procedures with US legislative and regulatory procedures. How was that done? Well, panels were to have been convened and to have reported within a certain time period, and the appellate body left with a very short period to exercise, in effect, what the common law people would call judicial review. Where have the members fallen short for some time? What was inherited from the GATT system was, dare I say, advisory opinions. Now, I don't mean an abstract referral, I mean actual case law through panels, but the reports are referred to the membership. And it's only if the membership agrees and adopts the results of a report at the dispute settlement body that it becomes binding. It is a negative consensus, as Simon Lester points out, but ultimately, if the membership reads a panel report, has a meaningful debate about what's said in that report, and offers a contrary view, it would be the view of the membership, not the panelists, that in effect would constitute the jurisprudence. The same is true at the appellate body level. Despite efforts of successive chairs of the dispute settlement body, and I put myself in that category as well, to provoke more meaningful discussion of the issues raised in various panel reports, the membership has failed to exercise and apply its responsibility to add its collective wisdom from capitals through their ambassadors and their representatives on the committee on what the rules should be. So there's fault there. Second, as Simon Evanet rightly pointed out, the members themselves have fallen short in exercising their responsibility to follow through on notifications in a timely fashion. Some are 3 to 5 to 7 to 10 years behind, particularly in agriculture. The difficulty, one of the major difficulties identified, is the detail and complexity now demanded in the various committees to try and meet the standards of uniformity and detail that Simon calls for to allow some comparison. One of the compensatory avenues to make up for that is the process of so-called cross notification, where a member can in effect notify potentially problematic measure undertaken by another country and thus trigger some review. And as Inu also pointed out, it's the members themselves that have failed to exercise the political will to have sincere discussion about outstanding issues. I can say from my time in Geneva, there's a very unfortunate attitudinal problem among most delegations, namely that as soon as you set foot on WTO premises, it's assumed that what you want to talk about is a potential negotiation. We have lost as a membership the confidence that raising an issue, having a discussion within the WTO can be just that, namely a discussion, without seeing the specter of a potential biased preference for one or another negotiating issue behind it. So I do see that as a very consistent common theme among our panelists today. Let me offer a few observations on some of the prescriptions and looks forward that each of them have offered. And I'll put them under 3 C's. Collaboration, capacity, and what I'll call caucusing. And let me come back to that at the end. On collaboration, there's a certain insularity within WTO quarters about talking amongst ourselves as trade aficionados without regard to affiliated institutions and forums. Take dispute settlement, for example. The notion of 2-tier review is not uncommon under World Bank auspices for investment disputes. The ICSID procedures provide for second-tier review. Some of the regional agreements, including the original NAFTA, carried forward into we call it CUSMA in Canada, putting Canada first, or the USMCA, has an extraordinary challenge procedure, as it's called, for binational review of anti-dumping and countervailing duties. What Simon Lester identified as a key issue is the scope of review. It's called an appellate body, but in many ways it was designed more as a judicial review, to look solely at the law, not to be a trier of fact de novo, and to ask itself more whether the panel acted within the bounds granted to it than what the parties were arguing. Again, the fault is in part on the parties, as Simon highlighted, the number of issues raised, of course, driven by domestic interest, to say, well, we raised every possible defense or offense is a problem, but there are lessons to be learned from other organizations. So too on notifications and on transparency. If we take SPS, sanitary and phytosanitary measures as an example, the procedures conducted under FAO auspices, under the International Plant Protection Convention, at Codex Alimentarius, you'll recall the BSE issues and so on, actually provide good fodder to compensate for some of the shortcomings. So too at the OECD on trade-related investment measures, and now their services trade restrictiveness index. Simon Evanet is right, however, that we're all a bit shy in WTO quarters at having regard to the readily available information, not only from the Global Trade Alert, but from multilateral and plurilateral international organizations in which the very same members participate. And there is, I think, a middle ground there to get that information onto the table and for the members themselves to consolidate. If we take EMA's very articulate survey, unified by the development dimension, whether fisheries or e-commerce, again, meaningful work undertaken, meaningful analysis done at UNCTAD on e-commerce, for example, on fisheries. While it's true that it's truly a multilateral issue, a good deal of the control over overfishing is exercised by a range of regional fisheries organizations, from the North Pacific to tropical and so on. It doesn't deal with subsidization, but it does deal with control. So in effect, all of this in the spirit of collaboration to look more meaningfully at what you might call multi-stakeholder governance of the challenges at issue. There is a heads of agency process, so-called, between the United Nations, the Bretton Woods institutions, and the WTO. It's conducted at the level of Director General and Secretaries General. It doesn't pan out as earnestly at a working level, it seems to me. That's one area where the Secretariat itself can invest some time and energy in terms of drawing out better collaboration with other organizations. My second C was capacity, and I think EMA has a fundamentally important message to convey, and that is the lesson of the trade facilitation agreement. Namely, special and differential treatment should not be viewed as an excuse for a permanent opting out from the rules, but rather an explanation of why capacity limits constrain developing countries, or certain among them, from being able to fully implement the rules. Thus, rather than looking at excuses, if we can better combine commitment and engagement on building necessary capacity with the appropriate and negotiated phase-in time necessary, so that ultimately, across whatever timetable, the end state is all countries living up to the same obligations. It's an approach that did garner international agreement on trade facilitation and can be applied to many other areas. The network of EU one-way preferential agreements with developing countries is a good indication of this, by incorporating capacity building into the preferential treatment offered. The US does less well with its GPT approach, which is sort of a harsh red light, green light. So if at 10,000 feet I'm right about the responsibility of the members themselves, then all three panelists said, come on, folks, get your act together and talk about it. How do you do that? Well, that's where I come to my caucusing notion. You know, there's I can't give you the exact link, but on the WTO website somewhere is a wonderful set of intersecting circles, almost a Venn diagram, that showed all the caucuses engaged in agriculture negotiations, from the Friends of Tropical Products through to the Cairns Group, and so on. And there were some 20 or 30 like-minded informal associations of members exercising their collective voice on issues or perspectives of interest to them. That still goes on a bit. There is, for example, a caucus known as Friends of Fish that is a collective advocate for attacking IUU fisheries. Some governments invest some time in building out that consensus, but there's also regional and plurilateral fora, such as the Ottawa Group with particular attention to dispute settlement, even the regional fora such as APEC and its trade ministerial process, and of course you have the G20 since 2016 having established a standing trade and investment working group, by its own admission, not there to negotiate, but to talk about things. So you build out consensus in a WTO context just as you would in the United Nations. You don't bring something directly to the floor of the General Assembly. You build out a consensus from like-minded, be it a G20, a G30, or so on, and you talk it up as best you can. Let me conclude by saying, how does this build out to re-engaging a forward agenda? There are practical measures and there are political measures. As a practical matter, as the MPIA illustrates, it is possible for subgroups to point the way. In addition to the Walker process on dispute settlement, Canada and a number of other countries have long had on the table a series of so-called practice notes that it's open to countries to voluntarily agree to modify the procedures they'll use in any particular dispute, for example, to limit the number of issues, to limit the size of pleadings, to adjust the timetable, and it is possible to lead by example. So too, in the transparency field, there are opportunities for members, including the chair of the relevant committee, to trigger informal discussion and caucusing around these issues. And as I said, and as Inu hinted on development issues, heck, that's a discussion that needs to be had not only in the WTO, but at the development banks, at UNCTAD, and at similar institutions. Finally, and this is the last point, maybe to trigger discussion among the panelists, one of the reasons for the lack of political will is the continuing hesitation, if not objection or fear, of more liberalization in many of our publics. Bob Koopman and company and similar research has shown in various quarters that the threats to jobs, the threats to well-being flow much more from technological advancement and from globalization or liberalization. We need to engage, not so much in Geneva, but in capitals, as Cato does and others, in better explaining the dynamics that go into, in effect, the permanent churn that is part of economies advancing. We do destroy jobs, but we create better ones, and ultimately better wages and more prosperity. We have to learn with domestic ministries, with our industrial policies, with our public communications, how to better explain and better engage the range of stakeholders at home in order to have the support to engage in the way I've suggested going forward. So I'll stop there. Lots of time for discussion. And thanks again to the panelists, because I think in many ways, all I've done is inadequately paraphrase the very rich observations and insights that our main speakers have already offered. So thanks, Christian.
Thank you very much for these very interesting thoughts, and plenty of food for thought really for us panelists, and I guess also for the audience, who I would like to invite once again to ask questions. We have enough time to deal with them, so please, we have some to work with, but please give us some more. We'll have the time to deal with them. Our first question that we have is for Simon Evenet, and what he thinks about the US proposals to sanction the failure to notify. Or I might add to that, what can we do to just provide more incentives for government to see that notifications are actually a good thing also for them, and not just an administrative burden that makes it easier for them to get hit with something if they do something other members don't like.
So thank you for the question. My instinct is to recoil at the idea of punishing people or indeed governments in situations like this, because essentially you want to elicit better behavior from people, and sticks are often the worst way to do that. I think we have to go back to a very fundamental discussion about why transparency and notification is important, and it's important so that we can make real these legal obligations that we've signed. We have to go back and explain why these notifications are important, why not notifying amounts to essentially violating the rules of the game. And that this is a first order problem. I would also put on the table, as I did in my talk, it's not evident to me that governments must be the only ones responsible for collecting information on or sharing information on what they're doing. I think I would certainly be one to say that I think governments owe a responsibility to their populations to be transparent, especially in countries which are democracies. We have that obligation. But when it comes to notifying to the WTO, of course, it's valuable in having a common basis. But if this system is breaking down, then maybe we need to have a separate international public sector body which collects this information. And again, I would go back to the fundamental point. Why do we have to lump monitoring and convening into the same organization? And if I can see complementarities and advantages of doing it, but if this system can't fix itself, if we can't persuade governments to take this up, take the transparency obligation seriously, then we could try an alternative configuration.
Thank you very much. We also have a question specifically for Inumanak, which is about the use of critical mass agreements and whether those would be a sufficient potential solution. And maybe you can also elaborate a little on other forms of plurilateral cooperation that are being explored and what you think of this.
Yes, I think this is always a tricky thing. You know, we look at plurilaterals as one way to move forward in negotiations, and I think we can utilize them in certain cases. I think it does work well in issues that aren't inherently completely multilateral, like the fisheries issues, which I think cannot be a plurilateral. It would actually defeat the entire purpose of doing those talks to begin with. But there is room to, I think, experiment and to bring other countries on board by doing plurilaterals first. It touches on Jonathan's point that, you know, we have to caucus, we have to find ways to build some sort of consensus. And part of the problem is when you have everyone in the room at once, it's going to be really hard to get the signal over the noise. And there's going to be lots of, you know, political sort of grandstanding and a lot of other challenges, I think, to actually openly discussing what needs to be talked about. And so in that sense, plurilaterals offer some sort of way to give us a little bit of space to have really open discussions about the issues. Now, one thing that I think is challenging to all of this, but also as a place we can learn from, is in the growth of FTAs. We have seen that what a lot of countries tend to do is to build these FTAs and then use those as models for how they negotiate bigger deals. Now, I think that at the end of the day, the most countries you have part of these deals, the better, because we're creating more streamlined rules that everyone can abide by much more easily. I think it's much more difficult for business to try to comply with various different sets of rules. So the more that we can multilateralize these things, the better, I think. But if we're stuck in a point where we can't move forward at all, I think plurilaterals are the way to go. But we have to be cautious about the increasing spaghetti bowl effect that we're seeing with far too many FTAs being negotiated with little odd rules here and there that I think are just making it very difficult for a lot of companies to take advantage of these rules.
Spaghetti bowl is a really good keyword, because we have another question by Michelle Egan, who says, how do we reconcile the fact that there is a proliferation of different groups of like-minded countries, which might lead to some sort of balkanization of the World Trade Organization, with the overall concept of transparency and, I guess, rules as a whole. So she mentions in her comment particularly Simon Evanet and Simon Lester, but I think this is a point on which maybe all of our panelists have something to say. So I'm not quite sure to whom to give the word first. Maybe Jonathan Fried, and then we go on from there.
Sure. Look, as I tried to flag over the history of trade negotiations and in other fora, the process of consensus building has shown the building out of core agreement from people coming at it from different angles. So take an extreme other end, although relevant to fisheries, the law of the sea negotiations. It wasn't North versus South or East versus West. You had a caucus of coastal states, a caucus of fishing states, a caucus of landlocked states, each bringing a somewhat different perspective to bear. Ultimately, the reconciliation of these different points of view led to common ground. The same in agriculture. If you have to have regard to tropical products on the one hand, agricultural exporters on the other, developing countries' subsistence farmers on another, then you need to have those perspectives well articulated, not by 164 countries, but by having them grouped together and brought to a common table. Add to that the evolution of what is increasingly becoming multi-stakeholder governance in new fields. Inu may wish to comment, but if you take e-commerce as a subset of the informatics and digital age, obviously private sector interests, civil society, privacy advocates versus the B2B commercial advocates, all will have a perspective that government trade negotiators are not necessarily expert on and need to incorporate. So you need to build out this dialogue. It's another angle on transparency in trying to understand what best suits the 21st century economy. One little anecdote: at the time of the original NAFTA negotiations, obviously, trade negotiations traditionally held confidentially because commercial interests were at stake. At one point, the negotiators said to themselves, you know, we should just scroll the draft text on C-SPAN and television for 24 hours a day. It'll put people to sleep and alleviate all fears, because there's nothing terribly nefarious about the things we're trying to deal with. So openness, as Simon Evanet has long argued for, should be seen as a virtue, not a threat.
Okay. Simon Evanet, since the question also mentioned you, do you want to come back in on this?
No, thank you. I have nothing to add to Jonathan's excellent remarks here.
All right. Any of the other panelists? I mean, Simon, is there a link can we see the MPIA as a like-minded group of a two-tier appellate body? And if so, is that a problem, or you would react to this?
Yeah, I'll just add in here to say that, I've never been a trade negotiator myself, so I don't have a sense of this as some others do. But from the outside, it makes sense. I've negotiated things in other parts of life, and you see how groups come together. Within the broader groups, some smaller like-minded groups come together, and it seems like a natural way to approach things. And as you say, Christian, I think the MPIA can be seen as an example of this. We have 24 parties, or more if you want to count the EU as all of its members, coming together and trying to go forward on some temporary appellate mechanism. But what about the others who are not involved? Is this like-minded group going forward? Is this going to destroy any hopes of a resolution here? I don't think so. I think it's just some people who agree, trying to find a path, and then those who do not currently agree can sort of look at it and observe, and can come together on their own and propose alternatives, or come together in separate coalitions, or just opt out. I mean, there's no guarantee of success, by taking one approach or another. But when some group feels strongly about something and has what they think is a solution, I think it makes sense for them to operate that way. And ultimately, you hope that brings. It sets up a framework that everyone can come together at some point. So I think there's no alternative to it. There's just never going to be a simple, well, let's all just get together and agree quickly. No, I mean, you're going to have different views, and you're going to have coalitions come together, and you hope it works out, and sometimes it does, sometimes it doesn't. I mean, not everything, obviously not everything can be agreed in international law and negotiations. The fact that we can't agree on an appellate body right now, it shouldn't shock us too much. There are plenty of things we can't agree on. But hopefully these like-minded groups can push us forward at least a little bit.
Actually, I do have something to add to this, and just sort of sparked the idea listening to Jonathan's comments. First, I'd like to say, if the text was put on C-SPAN for all to watch, I would definitely be tuning in. I think that's a great idea, and I wish we would have done it. And we should try something like that. But on the issue of broadening negotiations, I think Jonathan makes an excellent point that I think is often missed, that when we look at sort of the details of what's being negotiated these days, and e-commerce is a great example of that, where the issues are very technical. Now, if anyone has tuned in to Senate committee hearings in the United States, where senators are asked to talk about digital technologies, you look at the questions that they ask, often they don't understand the difference between Facebook and Twitter. These are fundamental problems. When you have people who don't understand the very basics and need to have that knowledge transferred to them by the experts. So I think to broaden negotiations, to make sure you have the people who are the stakeholders in these discussions, who have the knowledge to understand how these rules will impact the way that their businesses function. I think that's really, really important, and we should have that there. Now, fisheries is also a good example of that too, where so much of the issue is about fisheries management. And this is something that's so unique and interesting here, because it's not just about removing the subsidies, and this often gets forgotten. So we need to have people who are experts in fisheries management also involved deeply in all these conversations to make sure that we don't lose, the ambition that we need to get to where we need to get. So I think that raises a really important point that often gets forgotten, that it's not just about the negotiators in the room, but really making sure that we have everyone involved so that this is a truly inclusive open trading system.
Thank you very much. I'm just sort of sorting through the questions that we've got so far. And there is maybe one that links to what you've said earlier, about development. So in the question, it says that some of the biggest developing economies use development as a political stance especially concerning that is contend with joint initiative, it shows that the issue has deeper roots. In this scenario, and looking at the reality of multilateral negotiations, do the existing WTO rules and practices offer some alternative to boost negotiations?
Yeah, that's a great question. It's correct. Development is something that some members hide behind and do use it as a political tool in order to avoid making really substantive commitments. This certainly needs to change. Is there something that we can learn from within the WTO? I think that there is a lot we can learn from in terms of the way that developing members actually interact a lot and have quite a bit more capacity than some like to believe. One thing we can look at is in the committees themselves. You look at the TBT and SPS committee, very understudied area of WTO's regular work, something where developing countries are incredibly engaged, know the technical issues well, bring things up, and then challenge what some of the biggest economies are doing. I think this needs to be given a lot more attention, and we can give that more attention by talking more about all this work that goes on and putting a sort of a spotlight on the fact that we have an increasingly interesting amount of interaction happening at all levels, that is not just the sort of the stuff that gets on front page news or that sort of creates a political theater, so to speak. So there's a lot of functioning possibilities where we're actually having a lot of progress. But in addition to that, I think we maybe need to look outside the WTO itself to see how development works better. We look at what's going on in Africa. The African Continental Free Trade Agreement, I think, is a great place to look to understand how we can better incorporate capacity issues, and in addition to that, special and differential treatment in a way that is better tailored in a proactive sense to helping countries get to where they need to be. And I think this is something that we should explore more, is looking to developing countries to see how they're actually trying to figure this out, rather than trying to come up with a solution just at the WTO, because I think we're kind of at a loggerheads here, and some outside of the box thinking may actually benefit us a little bit more.
Thank you. Would any of the other panelists like to come in on this issue? Right. So in that case, I'm going to move on to another question that's been asked. And that is about how do we draw more attention to actually works well in the WTO, and how do we avoid the risk of talking the organization down to some degree, maybe by focusing so much on what doesn't work and maybe overlooking that the institution, even if it maybe not reaches its full potential, still has a lot of power. And maybe I would like to add to that, sort of what can we learn from the bits of the WTO that actually work fairly well for the bits that don't work so well, and how can we learn lessons from the better functioning parts? Any of the panelists want to come forward on this?
If I may, I'm going to put that to our panelists, because good research from credible outside sources that can offer assessments is the best evidence. And I think it's fair to say that most of the rules in most of the WTO agreements, and there are many of them from TBT to SPS and so on, most of the time are followed by most countries. And no news is good news to some extent. How you can measure and document the fact that, trade is functioning in many commodities and many services without hiccups, while in conformity with WTO rules that are repeated and elaborated in some of those hundreds of FTAs that Inu referred to. So it's, to me, responsibility of the public policy community, working with other stakeholders, to provide those observations on a more regular basis. But I defer to those running the institutions and their constraints. funding and otherwise, in terms of getting that analysis and getting that message out.
Any other comments?
Yeah, I'll just jump in. And so back in, I don't know, maybe the late 2000s, when I was blogging on the International Economic Law and Policy blog and just looking for material to write about, I noticed that I was mostly focused on disputes at that point, but, you'd get a period of a month or two without any new panel or appellate body report. You needed something else to look at. I noticed that the WTO would release summaries of what was happening at the TBT or SPS or other meetings. And I thought, hey, this is interesting. Let me write about this, sort of highlight some of the interesting things in there. And it kind of felt like at the time, nobody else cared about this. I was the only one paying attention. It seemed strange to me because it was very interesting stuff. But then I moved on to do other things. Now, more recently, and I'll let Inu talk about this if she wants to. We started working together, and she went off and got her PhD, and then she was doing her whole dissertation on the TBT and SPS committees. That had nothing to do with me. I mean, she just did that on her own. And so, since then, I feel like that is starting to come to light more. That's become an area of research. And I think when we've heard people claim that the WTO doesn't do anything or isn't functioning, it's provided an opportunity for us to say, well, actually it does. There's all this work going on, sort of on a regular basis, and you just haven't noticed it all these years. So I think, I guess it's an issue of just for those of us who are aware of it, just sort of take the opportunity to highlight it, and especially when we have this criticism out there that nothing's going on. It's an opportunity for us to explain that yes, there is, and it is important. And as Jonathan has said, people are actually complying most of the time and having great, interesting discussions. I don't know. It's not that glamorous, so I think it's hard to sort of get a headline out of it. It's hard to get the media to write about it. But I do think people have become more aware of it. I feel like this has come up a lot more in the last 2 or 3 years than it was 10 years ago when I was blogging and nobody was paying attention to it.
Good. Any other further comments on this point?
Yes, if I may, Christian,
Please.
I'd like to go back to the premise of your question, which is to say that surely something good is going on. I'm all for a very balanced discussion about where the WTO's strengths and weaknesses are, but I think we are at the stage where we need to ask some very fundamental questions about what governments want from this system. I mean, how many of them appear to be interested in signing new binding trade obligations? At least if the Doha round is anything to go by, not so many, or at least not enough. And how many of them, of governments out there, are willing to allow their development strategies and the way in which they want to manage capitalism to be mediated or influenced by binding trade obligations? And I have some doubts that there are countries which are prepared to be so constrained. And I think that we have to understand that the world has moved dramatically on from the early 1990s. This discussion we had earlier about development, I think, just scratches the surface of the fact that I think the willingness of governments to entertain external constraints on, at least in some governments, to entertain these constraints has diminished considerably. And this then has important implications for what can be done in Geneva. It does lead you, I think, more towards a world where we see groups of countries moving together at different speeds, perhaps not always using binding accords, perhaps other collaborative instruments. And maybe in putting the conversation that way, we can be a bit realistic and yet at the same time begin to identify opportunities for moving forward.
Maybe I can add a word, because there's a fundamental debate to be had behind Simon's question. If you go way back, and don't forget, we were in an era of a Cold War, of a state-led sphere of influence intersecting with the Western market economy. It was said at the time by a Canadian economist and trade negotiator, Sylvia Ostry, that You should understand the GATT as a system for reducing, as a regime for reducing system friction. That given that countries were making different choices domestically as to how they wanted to organize themselves, what you needed is a buffer to reconcile the two and to make it more level between them without interfering with sovereign choices at home. That functioned well when the focus was the border, and measures at the border allowed the two systems and their businesses to intersect. As rulemaking through the Uruguay round moved beyond the border to domestic areas of regulation, such as TBT and SPS, an impetus grew to try and harmonize, to try and have internationally standardized approaches. And it certainly makes sense for food safety because whether you're a least developed country or a developed country, you want to be able to buy and sell with the confidence for your consumers that you're meeting scientific standards. But then you begin to put into question in areas like industrial or agricultural subsidies, domestic policies. So as we look at what now has become resurgent, how to marry state-led economies such as China with market-led economies such as the United States and its allies, are we seeking, in taking up Simon's challenge to develop new rules, are we seeking a set of new codes that will reduce the system friction, or are we seeking harmonization of standards in such domestic areas as industrial support? And of course, that's coming to the fore right now in COVID, as we each seek to stockpile, as we each seek government investment to build capacity for masks and PPEs and so on. So the notion that it's just East versus West is not at issue. The notion of should the trade rules be dealing with the intersection of countries or with their domestic policies lies behind some of the challenges that negotiators face in trying to set an agenda. I'm going to stop there.
Thank you very much. So we now have a little less than 10 minutes, 8 minutes actually to be precise, left until the end of this session. So I'd like to turn to our panelists once again to wrap this session up in short statements. And I'd like to ask you, I mean, we have, of course, in the background of all this going on the competition, who will be the new Director General of the WTO? And I would like to ask you to reflect on all the elements of rebooting the WTO that we've had, how maybe they intertwine with the competition for becoming the new Director General. And suppose you were the new Director General, what would be the first thing you're going to do in your new job? I suggest we go in the order as we opened this debate. So Simon Lester, I'll turn to
That is quite a task you've given me. My new job as Director General. I mean, so on dispute settlement. So as I've already said, look, we've got to wait for the U.S. election to happen. We've got very different, very different routes forward in the United States. It depends who the president is. But whatever happens then, I think the Director General has to bring the key players into the room and try to get out of them what they want. I mean, what's your way forward? And here I'm really talking about the United States. What do you want to see happen in dispute settlement? Because we've got this big like-minded group who wants to preserve something like the existing system, and they're going to do it with or without you. They've made it clear, I think. So the United States, do you want to join this? Is there some form of what they're asking for that you can join? Or do you just want something radically different? Do you just want out entirely? Do you want a one-tier system? But we need some answers to that question. I mean, I don't know if this is a transparency issue. Maybe it's too much of a stretch, but unless we know what everybody wants, we can't get together on a solution. And so I think we've kind of been in a holding pattern the last few months as we wait and see what the way forward is for the United States. But once we know what it is, I think the Director General has to sort of bring the major players together and get them talking. And I'm going to use this as an opportunity before I wrap up to answer one question out there. Was what if we don't have WTO dispute settlement? Can we have FTAs deal with dispute settlement? Do we really need the WTO for this? And I think the answer is yes, because the coverage of FTAs is much more limited. When you have trade remedy disputes, you generally can't deal with them in FTAs. So I think WTO dispute settlement remains crucial, needs a way forward, and the new Director General, whoever that may be, is just going to have to bring everybody. I mean, I want to say knock some heads together, but really, I mean, there's only so much you can do. At least put people in the room and get them talking and get some answers so that everybody can move forward in whatever direction they want to go.
Thank you, Simon. Over to you.
Thank you, and thank you for this opportunity to have been part of this panel. I think my advice to a new Director General would be to go back to the sort of foundational questions as to what this organization is supposed to accomplish. Is it managing frictions, as we've heard Jonathan said? Is it liberalization? Is it harmonization? Or is it about making a system more transparent? And so countries can do what they want, but they must be transparent about it. I think a foundational conversation about that is needed. And the way I would hold it is I would say, well, what are we learning about the trading system we need as a result of the pandemic that we've just gone through? And ask, what set of rules makes sense given that we've now had the second major global crisis in 15 years. And this ought to be an opportunity to reflect on what we want from this system, what flexibilities we want to build into it, and where we want to take it. That would be my recommendation.
Very interesting. Over to you, Inu.
Well, I think, being the new Director General would be certainly a challenge for anyone. And there are limitations to what the DG can even do, and that's always has to be kept in mind. But one thing I think about when looking at what some of the big challenges are, I think about something that Bob Lighthizer actually said. If the WTO didn't exist, we would have to create it. Now, I think that this reveals something much more interesting than all the threats to withdrawal from the WTO from the United States, that there is something fundamentally very good that works at the WTO. And I think he knows that, and I think many people know that. Now, what the DG should do is take that at face value, that we don't need to be putting out fires everywhere they come. We don't need to be defensive about any ideas for reform. What we should be doing, as Simon even had pointed out, was that we should be having a discussion about foundational issues. We should be having a discussion about reform and not be afraid to sit down and actually openly talk about what some of the problems are. Because though the organization works, we do have problems, and these problems should be addressed, and we should be open about trying to figure out new ways to go about it. So I think the new DG should really just push to get people in a room and get them talking. If you have to lock them in a room and throw away the key for a couple hours, so be it. But I think that's the fundamental purpose of the DG at this point, is to just get everyone back to having that collaboration that is so missing right now.
Thank you very much. Jonathan, over to your final comments.
Yeah, well, I don't mean to have the final word, but a couple of observations from experience. Number one, it is fundamentally important for a new Director General to establish one's credentials as neutral. The demise of the infamous green room is indicative of the suspicion among some members that the DG is conspiring with a smaller group to push an agenda without full consultation. So whatever is done in the spirit that both Simons have identified of meaning, and as well, of meaningful consultation on some pretty fundamental issues, needs to be transparent. It also goes to Simon's other point about being a monitor and an advisor. That's not unique to the WTO. The IMF, of course, does surveillance does its independent and often harsh assessment of policies, but it also serves as a confidential advisor to governments. They've created firewalls within the same Secretariat to preserve the independence of those two functions. So number one, consultation by the DG, absolutely in a member-driven organization, but in a more transparent spirit than, dare I say, locking the door. Number two, deal with the most urgent and flagged, as did others, the opportunity to some extent that COVID presents as well as the challenge. Whether it's the kind of thing that the Ottawa Group and the G20 have called for, which is to reinforce the notion that any restrictions on supply chains and COVID-related goods should be temporary, transparent, and proportionate and limited. Whether it's expanding the exception for compulsory licensing from HIV/AIDS drugs to COVID-related pharmaceuticals, there's an opportunity here in common cause to be seen as responsive to a fundamentally global health crisis. Those two early confidence building measures do provide, I think, a good basis for a DG to build out from there. So I'll stop there.
Thank you very much. So the new DG should be neutral, remind the members of the fundamental values of the system, get them talking, and throw away the key. So I think we have a good recipe here. We have learned actually a great deal more than that, thanks to the brilliant insights of our panelists. It was absolutely fun to moderate this panel. I've learned a lot, and I would like to thank our panelists a lot for their contributions. That was absolutely excellent. To our panelists and our audience, I'd also like to remind you that there is a chance to continue this conversation on the Beyond the Trade network. You have the link to this in the general chat available to all of you. And with that, many thanks to all of you, my applause, and well, thank you very much, and hopefully see you again soon.